I'm going to hand over now to Matt Hervey. He is the partner and head of artificial intelligence at Gowling WLG. He's a leading expert on protecting and monetizing data and AI-related assets. He is the UK head of artificial intelligence at the international law firm Gowling WLG, and he coordinates cross-border and multidisciplinary advice on AI strategy for businesses of all sizes, from startups to FTSE 100 companies. And he's kindly going to speak to all of us this morning on protecting and monetizing data, algorithms, and other digital assets. We're going to have a few minutes for questions at the end, so please do be adding those into the chat. Matt, thank you so much for joining us this morning. Please come off mute, and over to you. Thank you.
Great. Thanks, Emma. I'm going to share some slides. Okay, so good afternoon, everyone. I'm delighted to be speaking today about protecting and monetizing data, algorithms, and other digital assets. And in keeping with the name of this event, I will use the term disruption a lot. Not something I tend to do, but I'm delighted to do so today. Emma's already mentioned my book, and yeah, I'm delighted to share with you just an oversight of what it covers, because I think when it comes to developing a strategy for digital assets, a sort of holistic view of the various areas of law and regulation involved are invaluable. So what I'm going to cover today is three things. First of all, an overview of the disruptive potential. You see, I've used disruptive already, the disruptive potential and the value of data and algorithms. Secondly, the legal tools for protecting and monetizing data and algorithms, and that's trade secrets, contractual measures, and intellectual property. And then some practical tips for developing and delivering an IP strategy. And I'm mainly going to illustrate these issues by reference to AI, because that is my expertise. And as Emma has explained, I help companies of all sizes with their IP strategy for AI. But broadly, the three key points are to recognize the value of digital assets, to understand that actually traditional IP rights and traditional IP strategies may not work in the main for digital assets. So you really need to harness a combination of traditional IP, trade secrets, and contractual measures to achieve your goals. So let's start with the value of data, algorithms, and other digital assets. And I'm going to use the example of the disruptive potential in machine learning. And the interesting thing is that AI research is really very old. It dates from the 1940s onwards. And it's really a dramatic leap in performance in the last 10 years in a subset of AI, specifically in machine learning, which in essence is computers programming themselves. And that has made massive performance improvements in previously intractable problems, especially vision and language. And when you crack those two, you open up all sorts of opportunities across all industries. So the opportunity to automate previously labor-intensive tasks. So vision is really the key to self-driving cars, but it's also a powerful tool for medical diagnosis. So one of our clients is involved in using machine learning for the rapid diagnosis of COVID by analyzing samples visually. And then turning to language, the example here is you can process language in order to review maybe thousands of documents in order to automate the assessment of an insurance claim. And this sort of automation, can transform the speed and costs of a business. So why does that matter to a chief disruption officer? Well, there are two key points. The first is that machine learning disrupts markets by enabling new entrants with lower costs. So to take the pharmaceutical industry an example, this is a slightly old chart, but drug discovery and testing has always been immensely costly. But in the last 5 years, we've actually seen around 1,000 startups in the life sciences sector, and they are relying on AI to dramatically lower these previously very high costs and to improve the success rate of testing. And to give you the standout example for the UK, Benevolent AI last month was valued at more than $2 billion, according to its latest investment round. The second reason it matters for disruption is that it can radically change traditional business models. So our automotive clients are using machine learning vision systems to manufacture and then sell autonomous vehicles as a product, But then they're expecting the industry to move. They're expecting to then sell mobility as a service. And then some of them are hoping to establish the vehicle as the all-important platform, a platform from which to sell services to customers en route. And like big tech companies, they're hoping to be involved in everything you search for, content recommendations, content sale, being a sort of virtual personal assistant. And along with big tech companies, and I've illustrated one of Amazon's products here, it's a chance to sort of take a slice of all of a customer's purchasing decisions, really to become, take a slice of economy itself. So let's look at data. So AI relies on a range of digital assets. So the learning algorithm, the trained models, but it's the training data that receives a lot of attention. And the revolution in machine learning has really been enabled by three things. The first is faster computers. The second is increased memory. But the third and critical aspect for almost all machine learning is data sets. And that is because data is really essential, especially to supervised learning. And that's where you take a very, very large labeled data set, such as X-rays, which have been labeled with the actual diagnosis of a real doctor, and you train an AI using those labeled data examples until it can replicate or even become more reliable than a real world doctor because it's learned from hundreds of doctors. Or you can generate new data. So you could take dash cam footage from a car and you can pay people to laboriously label every pedestrian, every cyclist, and so on. So again, you can train an AI to do the same thing. And in this way, access to the right data source may in fact be the key to an entire market, and the cost to buy an appropriate data source can run into millions of dollars. And moreover, the value of data is complex and it may change. So data is not used up if someone uses it to train an AI. And the value may be radically different to different parties. So to give you a wonderful example, just CCTV footage of a street could be used by one party to establish the geography of the street, another party to train an AI on driver behavior, another one to look at traffic flows, and a fourth one maybe using exactly the same data set to track weather over time. And data may be radically of different value in combination with data that one party may have access to and another doesn't. And we're also looking at an evolving market. So in the EU, there are very deliberate measures to create public data sets and also to create an effective data market in the EU. And that is both to encourage the sort of sale and transaction, but also to ensure we have the right IP protections so that people have the control of the data in order to actually monetize it. And we're also looking in terms of this sort of evolving market of the potential for forced access to third-party data, particularly against big data incumbents. And then concerns over privacy and data bias means that concerns whether your data set is in fact suitable may generate certain liability issues and may again have a knock-on effect on the cost. So I think the key takeaway on this is that given the uncertainties in the value of digital assets, this justifies a precautionary approach. So you want to maximize the protection or control of your digital assets, because if you forego protection now or lose control, it is usually gone forever. So now let me give you a flavor of what you can and can't do with IP rights. And I say flavor because I can't possibly cover all the nuances in the time we have. But the key point here is that most IP rights were not designed for digital assets. And so it's key to understand the gaps and to plug those with trade secrets, contract, practical and technological measures. So to give you an example, the fundamentals of European patent protection were actually developed in the 1960s when we were using mainframe computers, punch cards, very basic graphics and no internet. And so they weren't really designed with an appreciation of the importance of data or algorithm or digital assets. And indeed, some IP rights deliberately make it difficult to protect these sorts of assets. So in brief, the broad strokes of these, patents protect technical inventions, and there's been a massive rise in patent applications relating to AI. This chart here from the UK Intellectual Property Office shows around a 400% rise in the last 10 years to 2017. But you need specialist advice to work around the number of challenges, and I will mention two in particular. First, patents are not allowed for inventions that consist only of a computer program or a mathematical method or a method of doing business or a way of presenting information. Very broadly, you need to identify some further technical effect outside of these exclusions. And secondly, machine learning tends to produce code that cannot be understood by humans, the so-called black box. And that means it may be implemented by a third party in a way that is hard to understand, or indeed it may be in the cloud, and that cloud may be in fact in another country. And these factors make detecting and proving infringement of the patent difficult. Turning to copyright, that protects the expression in software, but not its functions. So it's a good tool to prevent employees or other parties with access to your code from copying it, but it cannot be used to prevent someone creating new code that does the same thing as your software. Copyright can also protect data, but only in an expressive form. So if the data is in fact in the form of a photograph or a written document, it would be protected. But it doesn't in fact protect the information per se, generally or in such a document. And indeed, in the UK and in the EU, there are certain exceptions, deliberately allowing third parties to mine copyright works for data without infringing the copyright. Now, the UK and the EU has a special protection for databases, which could cover, for example, data sets used to train AI. But there's a lack of reciprocal rights outside of the EU and the UK, which make it of limited practical use. And also, it's generally thought not to protect what's called spin-off data. And that's where the data would have been created by a business in any case. A classic example is a life sciences company, which runs clinical trials to test the safety and efficacy of a new drug. And the investment was made to test the drug. It was not an investment to make a database. So one so far untested possibility is that machine learning requires extensive pre-processing of data in order to make it suitable. And that's things like de-skewing, de-warping, cropping images, removing noise, downsampling. And it's specialist work, part science, part art, and it may count as the sort of investment in verification or presentation, which will allow you to use database rights. So I think the key takeaway on data there is maybe UK and EU companies should be recording somewhere the sort of costs they are incurring in pre-processing data in order to maximize their chance of attracting database rights. Now, given the challenges I've identified and the gaps in patent protection and copyright and database rights, it's particularly important that businesses dealing with digital assets pay attention to trade secrets and contractual measures. And I'll discuss those next and suggest some practical measures. So, trade secrets first. The brilliant thing is these are broad enough to protect any kind of information, and that includes algorithm and that includes data. And indeed, the largest dispute relating to AI to date, one in the US, was Waymo against Uber, and it ended up focusing on trade secrets, not on patents or other IP rights. And that's part of a general trend. Recent research published by the UK IPO noted a 14% annual growth rate in US trade secrets litigation from 2001 to 2012, and also found that 70% of UK firms which develop product and process innovations do use trade secrets. It also said that research showed that in the last 2 decades, businesses have come to prefer trade secrets to patents. Now, under international law, trade secrets have to be valuable because they are secret, and they have to be reasonably protected. So, for example, in the UK and the EU, our law specifically requires that a trade secret has been subject to reasonable steps under the circumstances by the person lawfully in control of the information to keep it secret. Now, what those steps are is not specified in the law, but you should be considering this sort of step. First of all, practical measures to keep information secret. So controlling physical access to the information, controlling electronic access to the information, things like permissions, passwords, but also logs of who has accessed it. Electronic restrictions or monitoring devices, so things that monitor transfers by email or uploads to cloud storage or transfers onto a memory stick. And then staff training, but also prepare in advance. Before you know you have a problem, you need to prepare in advance a fast response in the event that there is a breach, because the clock will be ticking. Once the secret is gone, once it's out, you may not be able to claw it back. And secondly, a series of procedural measures. So you want non-disclosure agreements with third parties, you want to have terms of employment that establish trade secrets vis-a-vis your employees. You want staff handbooks, policies, training, and the like. Now I'll turn to contract. Now, as with trade secrets, contract can be used to protect any kind of information, including algorithms and data. Now, first of all, contractual obligations are normally used to protect trade secrets. And so it's to specifically require the counterparty to employ the sorts of practical measures I've just outlined. But also, where a digital asset cannot be owned as IP, it just doesn't qualify, as between the parties, they can still agree who controls, doesn't necessarily mean owns, but who controls the assets and what each party is allowed to do with those assets. And this can be a very complex situation. Think of a self-driving car. You have the OEM, the manufacturer of the car. You have the equipment manufacturer, the chips, etc., the cameras which have gone into the car. You've got the dealer, you've got the servicing, after sales servicing, you've got the first owner, you've got subsequent owners, you've got drivers and passengers. So only really contractual measures can satisfactorily establish who controls data arising from these scenarios and what each of those parties is allowed to do with that data. Now, clearly, nuance and skill is required in defining assets and the uses, and also to navigate a path around terms that are not allowed in law. Now, your key toolkit, therefore, is trade secrets and contract, and act now to put in place suitable measures and contractual terms, and where possible, an effective patent strategy to navigate that excluded subject matter I talked about and enforcement challenges, to use copyright to protect code, but to be aware it doesn't protect functions, and to remember that data as mere information is largely excluded from conventional IP, but maybe record investments in processing data to maximize your chance of database rights. Now I'm going to end with this because this is where the rubber hits the road. So particularly when you're choosing between patents and trade secrets, you need to assess the risk of disclosure, because if you can't keep the secret, you're going to have a different solution. And that might be a patent. And that really needs a holistic view of the technology, the market, and current and developing regulatory risks. So just very briefly in outline, the first issue is reverse engineering. So reverse engineering of algorithms and training data is an area of increasing interest. Secondly, the demand for AI specialists typically is greater than the supply. And so it's a relatively mobile employee workforce. And so they need to be tempted in, often with the promise of being allowed to publish their research and findings. So again, if they need to publish, you need to protect in some other way. And also collaborations are very common in this field, often with academics who are definitely going to wish to publish. And then the final point is regulation. So we are increasingly seeing requirements to disclose aspects of algorithms and data sets to prove robustness and safety. And so I'm giving you two examples here. The first is the requirement to explain an algorithm under the existing data protection regulations. And the second is the brand new proposed regulation for AI, which again requires a degree of disclosure to users, among other things. So I'll leave you with this. No one size fits all. The balance between trade secrets and patents will vary sector by sector and business model by business model, but I hope I've steered you towards the questions you need to consider for your business.
Thank you, Matt, very much indeed. A lot to think about, a lot to cover, but thank you for simplifying that for those of us who are not nearly as strong in the legal world. So thank you very much indeed.